Good morning, and thank you for joining us today, Thursday, November 18th, for our webinar entitled Interactive Process, Understanding the Do's and Don'ts of Reasonable Accommodations, presented by Ethos Human Capital Solutions and Merhab Robinson Clarkson Law Corporation. My name is Denise Keddy, and I'm your moderator for this session. A couple of quick housekeeping notes before I introduce the topic and panel for today. Our webinar is being recorded and all attendees are in listen-only mode. The webinar will run approximately 60 minutes in total. Please take a moment now to visit the handouts area on the GoToWebinar toolbar to download a copy of today's presentation. If you don't see the handouts area, click on the toolbar to enable the handout area to appear. If you have any questions during the presentation, please post them in the Q&A area on the dashboard at any time during the presentation. If you would like your question directed to a specific panelist, please note that when you are sending in your question. Just a reminder that today's webinar is being recorded and all accompanying materials are protected by copyright, and this webinar is for educational purposes only and should not be construed as legal advice. We recommend that you speak to your professional advisors about the specifics relating to your business. Again, this information that we're discussing is as of today, November 18th. Reasonable accommodations have always been a hot topic, and this year is even hotter than it has been in the last couple of years. It is critical that employers understand how and when to engage in the process, and our expert panel will walk us through the process and some scenarios this morning. Our legal expert today is Kurtis Urien, associate at the law firm of Merhab Robinson Clarkson Law Corporation. Kurtis works in the firm's transactional department where he advises clients in real estate, finance, business succession, planning, corporate, and employment law. Mr. Urien also has been recognized as a rising star in superlawyers.com for the years 2017 through 2020. Our HR advisor today is Linda Duffy, president of Ethos Human Capital Solutions. Linda and her team are known for building the magic of the human connection with a unique approach to HR consulting, recruiting, training, and payroll support. The Ethos team works with your company by developing strategies for your business leaders to get the right systems, people, and culture in place within your organization so that you, as a business owner, can focus on running your business and achieving your goals. Before I turn it over to Linda, just one more comment. If you are an HR professional and you would like HRCI credit for today's webinar, please enter it in the Q&A section and we will be sure to follow up with you. And Linda, why don't you take it away?
Thanks so much, Denise, and welcome everybody. It's been a while since we've done a webinar, and we were very gratified that you haven't forgotten us. We had about 165 people register for today's webinar, so clearly this is a hot topic and everybody is hungry for information. As Denise said, if you are an HR professional and want HRCI credit for this, just put that into the question area, and then we will get back in touch with you. You will need to fill out the post webinar survey, but we'll send you a link to that. Also, because we postponed this, I did not go back into the HRCI system to update the date because they would not have given us approval in time. So just note that when you put in the digits for you know, the 6-digit code or whatever it is to get the credit, it will show up with the original date, which was a couple of weeks ago. Okay, still good though. All right, here's today's agenda. We've come up with a 6-step interactive process that we think is pretty easy to follow, and so we've tried to outline everything to give you sort of step-by-step on what to do. So we'll talk a little bit about the interactive process and the laws involved and then go through those 6 steps. There's a couple of other areas that sometimes come up that we wanted to just mention. One is service and support animals, another one is COVID-19. We could probably have done a whole webinar just on COVID-19 and the use of interactive process, but we're going to restrict it to one slide and then we'll take any questions that you have. And then the other 2 items just to talk about and think about with us is confidentiality as it relates to the interactive process, because we are dealing with disability information, and then also some do's and don'ts of people returning to work. And then, as always, as Denise mentioned, if you have a question, you can just drop it into the question section. If you don't see that, just go up to the main toolbar, look under view, and you can click the question section and it will miraculously appear. So we've decided when Kurtis and I were preparing for this webinar, the easiest way for us to do this is just make it very conversational. So we're not going to sort of split up the slides or anything like that. So we're just going to talk back and forth and share our experiences with it. And then again, at the end, answer any questions. So Kurtis, let's get started by talking about the laws that come into play. We clearly have the big one in California is FEHA, right? So it's going to apply to any employer with 5 or more employees. And then also the ADA, American with Disabilities Act, that applies to employers with 15 or more employees. So the first one is California specific. The ADA is nationwide. And I should also just say our disclaimer up front is we tend to focus solely on California law. Both of these do come into play. And you should always remember if you're outside of California on this webinar, just note, obviously, FEHA wouldn't apply to you unless you have employees here. Kurtis, are there any other laws that come into play here? Anything else that we should be telling our listeners today?
Yeah, thank you, Linda, and thank you, Denise, for the introduction. To answer your question, Linda, there are other laws that do come into play when an employee is making a request for an accommodation. The accommodation can come in a form of a change to the employee's work environment or policies or procedures, or it can become in the form of a leave of absence. So you also have to be aware of FMLA and CFRA, California version, when discussing and granting and reviewing reasonable accommodations. And the FEHA and the ADA also come into play too when you have an employee that's eligible for pregnancy disability leave. This PDL does allow for leaves in certain circumstances when an employee is pregnant, but there are also accommodations that have to be considered before the pregnant employee has their baby.
Right. And Kurtis, there's a couple of significant differences I can think of between these two laws anyway, that I think our listeners need to be aware of. One of them is, I know, because we see this on the Family Medical Leave Act certification form that we give doctors, that WH-380 form. It actually calls out, like, what's the diagnosis, right? But in California, we're not entitled to that information, right? And so
yeah, that's
one
right.
big difference.
Yeah, so Fair Employment and Housing Act, the California version, FEHA, is more restrictive, is more comprehensive. So when I'm working with clients or I'm working with employees with accommodation requests, I typically have conversations in terms of FEHA. I really don't discuss Americans with Disabilities Act. And well, that's if the employees in California. Now, if employees outside California, then Americans with Disabilities Act applies, as you mentioned, and any other state laws. But really, I just have conversations in terms of FEHA because FEHA is more comprehensive, is a little bit more restrictive. So you mentioned the Department of Labor form, the WH-380. It does ask questions about the medical condition. California doesn't allow that. So I actually advise my clients not to use the Department of Labor forms and rather to use California-specific forms.
Yeah, and
just because California, you can't ask what the disability is, and you cannot ask what the diagnosis is, and you cannot ask any conditions related to that.
right. Yeah, and I think, we always, if we do use the DOL form, we actually remove that word. You can edit it and remove the word diagnosis. But the good news is for everybody here in California, EDD, or DFEH rather, DFEH came out with a set of forms that can be used for CFRA. A lot of abbreviations going on there, I know. But if you just Google DFEH and CFRA, like doctor certification, you'll find the forms. And so you know that they're going to be California compliant if you're using those forms. So that's a good thing to keep in mind. So let's talk about what the interactive process is. And I've got some words here on the screen, but at the bottom, the bottom line end of the day, it's just a conversation, right? It's just a discovery process to say like, hey, here's a person that has some sort of limitation due to a medical condition or disability. And we need to figure out if it's affecting their ability to do some part of the job, an essential job function, right? So it's having a discussion with them and going through to figure out, hey, could they still do the job, whether or not, with or without an accommodation. So that's part of the process we're going to walk you through today. But I just wanted to clarify one other thing about this process. It actually does apply to job applicants as well as employees. And I think we often forget about that because we're focused on employees. But I know I've had this happen in my lifetime. A long time ago, I was working at a heavy manufacturing environment that we had a machine shop, and there was somebody that came in that was deaf that wanted to apply to be a machinist, right? So we had to go through this interactive process with that person. So it does happen sometimes, not as frequently as dealing with a pregnant employee, of course, but it's something just to keep in mind. And then, Kurtis, when do we need to engage in the interactive process?
Yeah, so the interactive process must happen timely. What does timely mean? Well, it means immediately, essentially, promptly. Don't wait around. Don't think about it. Don't delay. If an employee makes a request, respond, investigate as soon as you can.
Okay. And then are there circumstances, like what triggers it?
Yeah, so there are really, I see it as kind of two ways in how an employee can make a request for the interactive process. There's going to be instances where it's an obvious request, right? The employee comes to you and says, I broke my leg playing soccer. I'm going to have trouble doing my job the next couple months, right? That's an obvious request. That's easy to recognize. What's not so obvious is what I kind of refer to as you have constructive knowledge that an employee has made a request. So you might see that an employee is struggling. You might see that an employee is limping or having difficulty viewing their screen, their monitor, or is needing to stand up and walk around frequently, or is in some kind of pain. These are all observations that you can make of your employees. And when you make one of these observations, you basically are put on constructive notice. You should know that there's something wrong going on with the employee, and you should approach the employee and begin that timely, good faith interactive process. It could also come from a third party. Let's say employee A comes to you and says, hey, I saw employee B limping or was in some kind of observable pain. Well, again, that's that constructive knowledge. That's that obligation to start the interactive process to investigate, to approach employee B and to start having that conversation. Or it could also be a situation where productivity is noticeably reduced from an employee. You can go to the employee and say, hey, I noticed let's say you're manufacturing something. You say, I've noticed your manufacturing, your output is down 90% this month. What's going on? And the employee can say, well, I got hurt or I got sick. And then you can go into that interactive process.
Right. That's good. And I think the other thing to keep in mind, and people sometimes forget this or don't know this, I liken it to, well, let me just say it this way. They don't have to come and use the words like, we need to engage in the interactive process, or I believe I have rights under FEHA, right? They can use plain English. And what you should never do is say, okay, well, put that in writing and then we'll deal with it, right? We don't put any barriers up to them. Like if you have knowledge about it for any of these reasons, like Kurtis was mentioning, and the last one also is if, you give them their 12 weeks under, CFRA and they still need additional time off, you're going to have to go through that interactive process again, right? So don't make it difficult on them. We don't want claims, for that reason to show up. So let's get into the 6-step interactive process. These are the 6 steps. We're just going to walk through and share some thoughts about each one. And again, for those of you that have joined since we started, you will find a copy of the slides in the handout section. So just go onto your toolbar or whatever they call it, and look for the handout section, and you should see it there. And if you don't, go up to the main toolbar, look for view, and then just click next to handouts, and it should pop up there. Same thing with the question section. Okay, so let's start about the first one, Kurtis. Sort of the starting point of all of this is knowing, like, what are the essential job functions, right? And so, of course, it was great. I hate writing job descriptions. I'll just put it out there. I think job
Right.
descriptions are generally a waste of time, except that you need them for this process.
Yeah, that's right. And having a written job description is not a legal requirement. And like you said, it can be a waste of time. And also in California, California is an at-will state, so you can change the job description at any time. You can assign any duties to any employee that you want at any time. So job descriptions can sometimes seem like handcuffs or restrictions, but when it comes to assessing an accommodation request, they're very important, because the whole point here is to determine whether there are any reasonable accommodations that would allow the employee to perform the essential job functions. So we have to know what those essential job functions are. We have to establish those first before we can, we learn what the restrictions are and what we can do to come up with an accommodation. So you mentioned a job description, and that's one of the most important tools, because that's something that you can actually send with your employee to their physician, to their medical doctor, to be evaluated.
Right, and
But
that's
in addition
the
to
whole
the,
key.
go ahead.
Well, I was just going to say,
Right.
so you have to give the doctor something, right? We're asking a doctor, and I always tell our clients, like, we go by what the doctor says, right? If you think that if the employee brings you something from the doctor and you're thinking, this seems really wackadoodle to me, you can have the employee go to a doctor of your choosing, right? And then a third tiebreaker if needed. But you have to tell the doctor, like, here's what the job is. Otherwise, there's no context, right? You know,
Yeah. How's the doctor going to know what the employee can and can't do if the doctor doesn't know what the employee is required to do?
exactly. And so the EEOC has said, besides those three things at the top, whether the position, the reason the position exists to perform that function, it has to be something that's that critical, or the number of employees or lack thereof to perform it, right? Or the degree and expertise that's needed to do it. Besides those things, you can see some other things at the bottom there: actual work experience, the time spent performing a function. I know, like, when Ivana on my team writes job descriptions, she's really good about saying for each of those essential functions the approximate time or percentage as a percentage of time that's spent doing that function. So if it's something that's
Right.
done 2% of the time, not so critical, right? But if it's like 50% of the time, well, that's an essential job function, right? And then the consequences of not requiring that an employee perform a function. So if it's not getting done, is there a problem there? And then also, of course, if it's part of a collective bargaining agreement. So besides the essential functions, right? A lot of people, when they write their job descriptions, they're going to put all sorts of qualifications in and all of that. The most important thing for the purpose today of what we're talking about is making sure that you're spelling out the physical requirements of the job. And if you just go online, you can Google all sorts of checklists for this, but you want to make sure that you have the physical activities and demands spelled out, right? So is the person sitting, standing, walking, climbing? What are they doing, right? Are there repetitive motions? They have to type with their hands, or whatever, right? Environmental conditions, so if you're out, is it outside, indoors? What type of position is it? Are there hazardous materials used, right? So, and what level of physical demand is it? Is it sedentary work? Like, I sit all day as I type on my laptop and talk to people, right? Versus, am I, outside, swinging a hammer or something like that? Those can be very different when the doctor goes to determine what level of accommodation is needed and whether the person can perform the essential functions. And then, of course, if any, personal protective equipment is required. So that's like the very first step, is making sure that you are clear on those essential job functions and the physical requirements of the job. So that way the doctor can make that determination. Anything else you want to say about that, Kurtis?
I just want to emphasize Well, yes, sorry. I just want to just emphasize something we had on the previous slide, that it's an individualized assessment each time.
True.
That it's gonna every time you get a request, the assessment and the process is going to depend on the individual facts and circumstances of that employee.
Yeah, and so sometimes you feel like you're in this like loop, right? And then we're going to do it again. We're going to do it again every time something changes, right? Or the person comes back from a leave, or then they have a secondary issue. So yeah, but it's very individualized. It's very fact specific. So when you call the attorney or you call us or something like that, we're going to ask a lot of questions about what's going on with that particular person. Okay, so the second step in the process after we have the job essential functions laid out is to identify whether there's any restrictions or limitations, right? So you want to just, put on your, detective hat and start gathering documentation. So it, of course, starts with that job description and essential functions. If there's a doctor certification form or a note from the doctor or something laying out any sort of restrictions. This person, can't work for more than so many hours a day. They can't lift more than 10 pounds, whatever that is. Also, what you've observed, what the employee has told you, right? All of that. And so you want to find out, is this person have a disability? Because we're not talking about accommodating people just because they want an accommodation, right? It needs to be tied to some sort of medical condition, some sort of disability. And so just have a conversation with the person and find out what they can and cannot do. And then really important is just remember, only ask what's necessary, right? And do not ask for a diagnosis. I mean, we already talked about that, but I can't emphasize that enough. Anything you want to add to that, Kurtis?
Yeah, so the medical certification from the doctor or for the physician is very important here. It drives me nuts when the employee sends over a doctor's note that says something simple or basic like, the employee is under my care. Well, that
Right.
doesn't mean anything. That doesn't tell me what the restrictions or limitations are. And so what we usually have to do in that situation is send the employee back to their doctor. And you can do that. You can send the employee back to the doctor to get better instructions, to get better information on what the restrictions and limitations are. And even then, if the doctor's still not participating or complying, you can send the employee to your own clinic, your own doctor that the company selects to have a fit for work physical to try and get a better idea of what those restrictions and limitations are.
And that's a really good point. I mean, we had that come up with a client recently where the doctor's note said that a woman needed a flexible work schedule. Okay, well, what does that mean? Right? We didn't have any idea.
Yeah.
So we gave her the certification form and said, go back to your doctor and have your doctor complete this, right? Because it's, if it's just a blank piece of paper, the doctor's like, okay, flexible work schedule. That's probably a phrase the employee used. I need some flexibility in my work schedule. Okay, flexible work schedule, right? But that doesn't mean anything to us. So it needs to be like, is it a start time, a stop time? You need extra breaks during the day.
Yeah, certain days.
Right, certain days, like what is it that you need? So it's important to get absolute clarity about this. Don't make any assumptions, right? Don't go overboard and, with some level of specificity that's unnecessary, but you want to make sure you're not making assumptions about what a flexible work schedule means. Really important that you document this whole process, right? So you can prove that you actually went through the interactive process, which is a requirement, but you want to be able to refer back to notes. So, take notes of all conversations, what was said, who said it, who were in the meetings, all those type of things, and keep that information in a confidential file just so you can limit access. So most of us in HR know that we need to have, two separate files, like, personnel file where you can keep the normal day-to-day stuff, and then a separate confidential file for like medical information. That's where I would keep it, is in that second file, which is confidential. And that way, if a supervisor comes in and wants to see the person's last performance review, no problem, but they don't have access to all of the medical information that we're discussing. Okay, so after we go through and we've written the job description and we have the essential functions, and we take that second step, the next thing is we're going to brainstorm some possible accommodations. So Kurtis, why don't you kick it off and talk about what a reasonable accommodation is?
Yeah, so the law is to engage in the timely good faith interactive process. So good faith means that you actually have to try. You actually have to be creative and work with the employee to come up with an accommodation that would allow them to perform their essential job functions. Now, this can come in the form of changing the job application process. We mentioned before that California applies to job applicants. So you want to make sure that your job applications are done in a form that can be easily submitted, and that people who come for an interview are able to access your work site, etc. And for existing employees, this might be changes to the work environment. If somebody needs to stand, you might have to get them a standing desk. Or if somebody, say like, well, for me, about 3 years ago, I broke my arm playing some sports activities outside of work, and so I had a cast and a sling for a period of time. So we worked with the firm here to come up with some ways where I'm still able to work. And back then that included some working remotely, before COVID started. But you just have to be creative and come up with changes to the work environment, to the procedures that allow the employee to work, that enable the employee with the disability to enjoy those equal benefits and privileges of employment. It's tough to come up with a bright line rule of what this means, because there really isn't one. As we mentioned, it's an individualized assessment. So the accommodation that you come up with is going to be based on the individual facts and circumstances of that employee.
Yeah, and let's look at some other examples of some reasonable accommodations, right? So as Kurtis mentioned, it could be, finding multiple ways of applying for a job, right? Changing job duties, obviously. We're going to talk in a second what it's not, because I know some of you are going to say, but, do you have to eliminate an essential job function? Nope, the answer is no to that, and we'll discuss that in a little bit. Obviously, giving time off or providing a leave of absence often comes up, right, when we have this. And that may be the best answer in certain circumstances if you can't change an essential function, or you can't provide an accommodation that would allow them to perform the essential function, is a better way of saying that, right? Changing work schedules comes up a lot. We have some examples of that as well. Relocating the work area, or as Kurtis mentioned, allowing people to remotely work is often accommodation we see these days. You could provide mechanical or electric aids. That may be something, or modifying a policy. We had a situation, again, we'll talk about, where we actually changed a policy for somebody. So there's different ways that you can do it. There's no necessarily right or wrong way to do it, as Kurtis said. You just need to, for that particular individual, what is going to allow them to continue to perform the functions of the job or apply for the job if we're talking about a candidate. So here's a little quiz, and we were hoping to do this as a poll, but it didn't work out from a technology standpoint. So we're just going to have you go through this. But which of these is or are a request for reasonable accommodation? So if an employee tells the supervisor, I'm having trouble getting to work at my scheduled start time because of medical treatments I'm undergoing, is that basically constructive knowledge, as Kurtis would say, of the need of a reasonable accommodation? What if that employee tells the supervisor, I need 6 weeks off to get treatment for a back problem? The third one, a manager notices that an employee's wheelchair cannot fit into the desk in our office, right? Fourth one, an employee tells the supervisor that he would like a new chair because his present one is uncomfortable. Is it all of the above? Is it none of the above? Or is it the first three only and not the fourth one? What do you think it is? You can go ahead and type in your answer into the question section, and we'll just see if we can quickly see any, any idea here. We see one person says 5 already. So yeah, so just type in a number. So I'm seeing 5s, 7, 5s and 7. 5 and 7 seems to be the common threads here, common themes, literally going back and forth, 5, 7, 5, 7, 5. So, okay, great. So yeah, so the answer to this question is actually 7. Number 4 isn't technically a request for reasonable accommodation because it isn't linked to a specific disability or medical condition, right? Now, if that person, if we switch it up slightly and we said the employee comes to the supervisor and says, I need a new chair because, I have a back condition, right? And this one's really, making it worse or something like that. Then you would go through that interactive process with that person to determine what those limitations may be. Does he need a different type of chair, something like that. But we want to make the connection between the need for accommodation is tied to some sort of medical condition or a disability. Anything you want to add to that, Kurtis?
No,
All right, then we're
you got
moving
it.
on we're moving on to the next one then. Okay, so some of you may already know about this, but I'm going to tell you there is an organization and it's called the Job Accommodation Network. And Jan, in short, is your friend. Believe me, I've used it many, many times. They're a great resource and it's a free resource. So I put free twice in the second paragraph because it's a free resource, right? And if you go to askjan.org, what you'll see is that they have a whole bunch of resources for helping companies and helping employees understand what accommodations exist. And so when you're stuck, because I've had that happen before where I'm like, wow, I don't know what to do about this situation. Like, how can we help this employee perform the essential functions, but we don't really have a solution for this? We picked up the phone and we called Jan, and they've got people there that can talk it out with you and help you. They also have this great tool called SOAR, which is an online resource. And you literally can go in and say, okay, here's the medical condition, here's the restriction, and you can keep sort of taking it like, down more specifically. They ask you a series of questions, you can click on them, and then poof, out comes like a list of potential accommodations. So I find this really helpful. So if you don't know about Jan, I hope that you will take a look at that and use that in the future, right? So the other things that you can also do, obviously, is you can ask the doctor, if there's any reasonable accommodation. So again, the doctor is usually going to say more on the restriction side, but you can always, I shouldn't say you should ask the doctor, the employee can ask the doctor. The doctor could maybe say like, here's what, this person should do. And maybe it's something that the employee needs to do on their side in terms of wearing a brace or, something like that, right? The other thing, just keep an open mind about this. We're going to tell you in a second what you're not required to do. But at the same time, I always say, if this was your best friend and you were trying to help your best friend out, how far are you willing to go? Right? So if you approach it as, okay, let's work together to try to find a solution to this, you know how tough it is to recruit right now. You know what turnover costs your organization. So anything you can do to keep somebody employed and working on behalf of the company is a good thing, in my opinion. So just, the other thing I would say is ask the employee for input on what they think an accommodation would be. So here are some examples of things that have come up. We had a client about 5 years ago or so. They had an accounting employee was waiting to have knee surgery, and she was working upstairs. That's where accounting was. The problem is she couldn't walk up and down the stairs, but the files were up there as well. And so we actually provided her with a cubicle downstairs, and then a coworker simply brought her the files that she needed. Right. So a couple times a day, she would call. Somebody would bring her a stack of files. She'd call. They'd take them back up, get her a new stack of files. Right. Once when we actually had her in the engineering department, and then the engineering department needed their space back because they were hiring. So we were scrambling to find someplace else. Now they ended up keeping her downstairs, but when we called Jan, they said, well, obviously in this case, it was going to be cost prohibitive to have an elevator installed in a small business, right? But they said, well, what about one of those mobility devices? You've seen those late night commercials where somebody's sitting on the chair and it takes you up the stairs, right? So they actually took a look at pricing for that as well. So again, Jan helped us with brainstorming new ideas on that one. So let's talk about, Kurtis, what it is not, right? Because I think a lot of people start to get anxiety thinking, oh my gosh, we're going to have to do this and spend all this money
Right.
and everything like that. So talk to us about
Yeah.
what a reasonable accommodation is not.
So we'll get into the details a little bit more in just a minute about the process to deny an accommodation if it's unreasonable. But these are just a couple examples of requested accommodations that are clearly not accommodations, they're clearly not reasonable. And the law and the EEOC and the DFEH have all agreed that these are areas that are just not accommodations that employers even have to consider. So the lowering of productivity or quality standards. If an employee says, well, I can only produce 90% of my output, that's not a reasonable accommodation. Or if somebody has a request where they don't produce as high a quality work, that's not an accommodation. Or if somebody says, my supervisor is stressing me out, I need a new supervisor, sorry, not an accommodation. The law will not require you to replace a supervisor or to replace any employee. Or if it's a request to eliminate an essential job function, not an accommodation. Or providing a personal use item such as a prosthetic limb or glasses. Glasses comes up a lot with employees who are having trouble, difficulty seeing. Providing a medical device is not an accommodation. That's something that's on the employee to provide. Or
Right.
excusing a uniformly applied conduct rule or displacing another employee, as you mentioned. The law is clear that these are not accommodations that the employer even needs to entertain.
Yeah, and that fifth or sixth bullet, whatever it is, excusing a uniformly applied conduct rule. What that means is this: is you don't have to allow an employee to be violent, let's say, right? Or say, well, that person has this condition that makes them violent. They're prone to violence, so we just have to suck it up because they have a disability. You don't have to do that. We're not talking about other things. Like I have an example in a second about meal periods and switching around break times and stuff like that. We're not talking about something like that because that's not going to impose a big burden on the company, but you certainly don't have to all of a sudden create a situation with workplace violence or something like that because somebody has a medical condition. So Kurtis, I'm going to speed us up a little bit because I'm watching our clock and I know we still have a lot to do.
Good.
So number 4 is assessing the feasibility, right? So taking a look at all of those accommodations that you just brainstormed and figuring out, okay, what is reasonable and what's unreasonable about our list of accommodations, right? So some of the questions you might want to consider are, what is the cost of each one of these, right? Will this actually allow the employee to perform the essential functions of the job? Because otherwise, why do it, right? It's like we're trying to solve a very specific problem, which is allow this person to continue to perform the essential functions. So make sure that the accommodation will do that. What's the degree of difficulty in providing this? What's the impact on the business operations? Is it going to create other safety concerns, right? And what are some other creative ways to allow the employee to work, that has acceptable impact on the business? So also, consider the employee's preference. You're not required to choose like their number one preference. But if there's 2 or 3 solutions and they have about the same cost or about the same impact on the business, then why not choose the one that the employee has a preference for, right? And then the last thing that I would say is, consider a trial period, right? You don't have to necessarily say, okay, this is what we're going to do, and we're going to accommodate you this way for the rest of eternity, right? Start out maybe 30 days, 60 days, 90 days, but put it in writing that we're going to try this accommodation, and you'll see that that's one of the next steps here, right? Is implement it, but then follow up and test for it as well to make sure it's actually doing what it's supposed to be doing. So here's another example of an accommodation that's pretty simple to solve, right? We noticed an employee, this is one of our clients a number of years ago, we noticed an employee was really having a hard time meeting the productivity expectations of the position. And so we were trying to figure out what was going on, and sometimes employees, you have to sort of poke around a little bit because the employee is reluctant to say, yeah, well, I have a problem or I have a disability or medical condition, because they don't know what will happen when they say that, right? So in this case, it took a couple times writing the person up for not meeting the expectations. And finally, he said to us, well, I've got this degenerative eye disease, right? And it makes it really hard for me to see small print. And he worked on the computer 100% of the time. And so we talked to him and we said, well, what would help you? Is there something we could do to make it better? And he didn't ask for glasses, Kurtis. He asked for a large monitor. And so it was like all of $250, problem solved, right? That's all it took. So sometimes it can be a really simple solution. $250 is not going to be a huge impact for any company, right? So that's an easy one. Here's another one I just sort of referenced a second ago. We had a pregnant employee who provided a doctor's note saying that she needed a different schedule because she needed to cook her own meals during the day and eat more frequently. So she was cooking her breakfast in the morning and then she was going to the office. But then if she had to wait for 4 or 5 hours before her lunch, it was too long. And so all we did was just shift her schedule around a little bit to let her take her lunch earlier in the morning. And that solved the problem. And she did that. And then she took her break and she could prepare food during the day and then go just heat it up real quickly for herself. And then that solved the problem. So again, that can just be a change of a policy, a shifting of a schedule. It didn't impact anybody else. You know, it just allowed her to get what she needed so she could continue working. This one, Kurtis, you and I are both on. You want to talk about this one a little bit?
Yeah, so this is an employee that notified their employer that she's having a lot of stress, and the stress was causing issues at work, causing productivity. And stress is a mental condition that's covered by FEHA and the ADA. A person can be clinically diagnosed with depression or anxiety or a number of other mental conditions. So this is another example, another situation where we had to go through the good faith interactive process. But in this particular situation, the employee was refusing to meet with their supervisor. And as we mentioned before, you can't, replacing a supervisor is not a reasonable accommodation. There were other things that the company was willing to do and willing to accommodate, but this employee was not participating, was not responding back very well, and so the company actually went to a position where they had to let her go because of her poor performance and suffering so much.
Right. And she was the one where the doctor said needs a flexible work schedule and needs a new supervisor. And we were like, no, it's not going to happen. Right. Because again, the employee has to participate in this. It's not okay for the employee to say, well, I don't want to work with this supervisor because, he causes me stress. Well, the stress was you're not doing your job. Right. And I think we've probably all seen that before as well. So again, if it's related to a medical condition, we're going to go through the interactive process, but we don't have to give the person a new supervisor, to be compliant with the law on this. So let's talk about when you can deny a reasonable accommodation. The biggest category is when it causes an undue hardship, but keep in mind that hardship is relative, right? So I always use the example of, if Bank of America, if, Boeing, Amazon, a large employer like that is, if they have to spend $10,000 to do something to install a mobility chair in a hallway, right, or something like that, a staircase, it's not a hardship on them. It could be on a smaller client, right? If my business had to all of a sudden come up with 10 grand to install a chair, it's a lot harder for me to do it than it is for Boeing to do it, right? So it's relative, okay? If it's significant difficulty or significant expense, then that's going to come into play. So obviously cost is a big one, but and if you go out and read anything about the interactive process and reasonable accommodation, they'll also remind you on cost, you have to look at, is there funding available from some other resource, right? Is there a grant you could apply for to get funding, or a state rehab agency, could they come into play here? A tax credit, a parent company, any other way to get money to do this. So don't just say, oh, well, I don't have money in my checking account right now. That's not going to basically come into play. You can also deny reasonable accommodation if the person doesn't have a disability, right? So again, there has to be that nexus between a disability or a serious medical condition and the requested accommodation. So if there's no disability related need for the accommodation, you don't have to provide it. And then you don't have to do it if there's going to be a direct threat to the health or safety of others, right? The biggest thing though, Kurtis, I think we should just discuss, and maybe you can weigh in on this, is the fact that you just can't deny a reasonable accommodation because you're like, oh, well, other people are going to think it's unfair because that person gets a different schedule, or, something like that. That person is perceived to get some sort of benefit. So what would your advice be to employers on how to handle that?
Yeah, so you still have to grant the accommodation if it's reasonable, but if other employees are complaining or asking questions about why employee A is giving special or preferred or beneficial treatment, you really, and we'll talk about this in a second, but you have to maintain the confidentiality of that employee's disability, and the response really should be something along the lines of, this is something we're doing for employee A, and that's it. And just kind of shut down the conversation and say you're not willing to have the conversation to talk about somebody else's circumstances.
Right. That's great advice. Okay, so here's something that I actually found on somebody else's form and I loved it. And it was just, you should document your decision making, like I mentioned before, right? Any meetings you have, any conversations you have, doctor's notes or certifications you have, all that should go into a file. The other thing to document is what were the accommodations you came up with, and then going through that analysis of, what's reasonable, what can we afford to do, or what isn't going to be a burden on the company, and why you made the decision you did. So if you're going to deny a requested accommodation, this might be a good type of form to have that you can document why you did it. So if later on that employee brings a claim or somebody comes in and asks and says, well, wait a second, this person requested this type of accommodation, you can look back and say, oh, you know what, this wasn't going to, be okay to do because of some reason, right? And we rejected it for this reason. And then just hold on to that documentation in that same file. Okay, the last two steps we sort of put together because they sort of go together in my head anyway, which is, implement the accommodation that you select. Again, I would recommend on a trial basis, and then just monitor it to see if it's effective or not, right? So take all of the necessary steps to implement that accommodation. If it's equipment you're ordering, like, the screen or assisted mobility device or whatever, you know, make sure you order the equipment. If you are going to change a policy or procedure, put that in writing, and then just communicate it to the essential personnel. So a lot of times that's going to be a direct supervisor. Again, they don't need to know the nature of the disability, nor do you, but if, you might have some knowledge because usually employees will disclose that, but you're just going to say like, hey, going forward, this person's going to have a different schedule, something like that, right? And then just monitor it and make sure that it's doing what it's supposed to be doing, right? Check in with the employee, check in with the supervisor. Are they able to meet, the requirements of the position now that they have this accommodation? And if it's not working, try something else, right? If it is working, great, then just move on. All right, Kurtis, anything else you want to add about the 6-step process?
Yeah, it's just that it's a process, right? Like you were saying, you monitor it and you continue to work with the employee and communicate how things are going. And when you've identified an accommodation and it's reasonable and you prove it, again, I want to emphasize labeling it as a trial. Because I've had situations where an employee and an employer identified an accommodation, implemented it, and 30 days later it's not working. Well, by calling it a trial, you're basically saying we're going to test it out and see how it goes. And if it doesn't work, then we can take back the accommodation, or we can change it or do something different. Because you don't want to get in a situation where you tried something and it's not working, and the employee says, well, if you take this accommodation away, you're discriminating against me. So it's very important to establish that it's a trial and it's a process, and that you're continually working to figure out how to accommodate the employee.
Right. And it could also be that it's a temporary situation, right? A pregnancy doesn't last forever. So don't, make sure you put in writing this is going to be a temporary accommodation until which time the employee is no longer pregnant or no longer needs it or something like that. So the employee doesn't come back, to work afterwards thinking, oh, well, I'm going to go back on that reduced schedule that I had, or whatever the case is. All right, so that's our 6 steps. Hopefully that's helpful. We have some related issues, and then Denise, be looking out for those questions. We're gonna take questions in just a few minutes and try to get as many in as possible for the end of the hour. So I will pre-frame the next few slides by telling you that neither Kurtis nor I have had this come up. Some of you may have, but we just wanted to just inform you, right, that accommodation may be a service or support animal. So both of those two categories fall under this general category of assistance animals. So it's, an animal that performs some sort of assistance for the employee in terms of, something related to their disability or medical condition. So with a service animal, it's an animal that's been trained to perform specific tasks like guide dogs, right? Signal dogs, even miniature horses. Don't ask me about that one. I've never seen a miniature horse in an office. They don't have to be professionally trained or certified, and that's where this gets a little bit messy, right? Support animals are more, emotional, cognitive, or similar support, companion animals, things like that. I do recall a client a long time ago where an employee was requesting to bring, I can't remember what the animal was. It wasn't a dog, but something else to work because it reduced her stress, right? She had like a high anxiety. And so they basically took a cage of some kind and built it in like a warehouse area where she could go down on breaks and be with the animal or something like that and then go back to work. That's like literally my only remembrance of anything like this ever coming up, but just wanted you to be aware of those things. You only can ask a couple of questions. Are you an individual with a disability, right? Like what's going on there, and what's the disability related task that the animal has been trained to perform, right? You cannot ask them for a demonstration of the task, although that would be pretty cool. So you're limited in what you can do. There are some things that you should know about this. Employees can be required to cover the cost of repairing damage caused by the animal, right? There are some, you can't really specify breed, size, or weight restrictions. And there is something, though, under Food and Agriculture Code 31601 that says that if a dog has been determined by a court to be a potentially dangerous dog or a vicious dog, pretty much that's because it's, a threat to others, then you can say that you don't want that dog on your property. But I will tell you, when I looked that up, it wasn't like it was a list. It was it was sort of more general than that. So it didn't say like by breed, here's what it is. And then you can require restrictions, like the example I just gave you. They said, okay, you can't, it's not like she could have the animal at her desk, but it was on the property so she could go to it frequently. You can require dogs to be on a leash. So you can put reasonable conditions on it as long as it doesn't interfere with their ability to do that. All right, Kurtis, COVID-19. Has anybody heard of that?
Yeah. I
Seems like
haven't had as many issues on this lately, but for a while there, it seemed like every day I was getting a phone call from a client saying, I have an employee that says they're stressed out over COVID.
Yep.
And it was driving me nuts because there are some red flags when somebody says, I'm stressed out over COVID, right? So if they have a stress injury or a mental condition related to stress, there might be some workers' comp implications. There might be some interactive process implications. And then the employee also might be raising some safety concerns at work. Maybe the workplace hasn't implemented the proper and the prescribed safety protocols. But as we mentioned before, stress can be a mental restriction. So when an employee says they're stressed out over COVID, you do have to explore that and address that with the employee. One, make sure that your workplace is safe and is implementing all of the safety protocols. And then two, just try and figure out if the stress is something that's work related despite the safety protocols, or if it's something that's going on outside of work. And then if they absolutely need an accommodation, then go through the process, get a note from the doctor, and so forth.
Yeah,
and then many employees have.
I'm sorry, let me just tag on that. I was just going to say, yeah, and we also have situations come up where people may need a leave of absence, right? Or maybe they're a long hauler, right? Or they've had a really serious case. Like a friend of mine called because a brother-in-law or somebody had been in the hospital for like weeks, right? And so he was trying to figure out, what should they be saying to his employer, right? And things like that. So you're going to go through that interactive process. When somebody needs additional time off, somebody's going to go out on a leave of absence and then it's going to return and can't, needs some sort of accommodation to do their job. Go ahead, Kurtis. You want to talk about
and with the vaccines that became available the past 12 months, many employers have been implementing the vaccine mandate. And as we've discussed, I think we've discussed this in previous webinars, that the vaccine mandate is allowable. An employer can require their employees to receive the vaccine. But the employer does need to engage in this timely, good faith interactive process to determine if a reasonable accommodation is available if an employee says they have a medical condition that precludes them from getting the vaccine, or if they have a religious objection. So if an employee has claims a medical condition that prevents them from getting the vaccine, you just go through the process. You identify what the requirements are, the job requirements, that's getting the vaccine. You send them to their doctor to get a note. The doctor comes back with a note. And if the doctor says, yes, the employee has a condition that precludes the vaccine, then you have to explore what those accommodations are, whether they're reasonable. And this isn't just a pass to not get the vaccine. It's an actual accommodation request. So what does that mean? Is the accommodation something where the employee can work from home or can have their workspace moved so they're not within certain proximity of other employees, or is it something where they can wear appropriate personal protective equipment? Again, it's an individualized assessment, but it's not just a pass on not getting the vaccine. It's how do we change the work situation? How do we change our procedures and protocols so this person can not get the vaccine but still work? And again, for sincerely held religious beliefs, there are religions out there in the world that have in their doctrine and their tenets that their members or followers don't get vaccinated. And if somebody is a member of that religion or has that sincerely held belief, then again, you have to engage in the timely, good faith interactive process. And a person doesn't necessarily need to be a member of a religion that doesn't allow vaccines. It's a personally held belief. So sincerely personally held belief. So a person could be a member of a religion that is in favor or promotes vaccines, but they still have their own version of their religion or their own practices or sincerely held beliefs where they're not allowed to get the vaccine. So you can still engage in that timely, good faith interactive process.
Yeah, we just got done with a big project for one of our clients who has employees that go out on military sites. And so they're requiring the vaccine, but there were, a dozen or so employees who requested an exemption. So they engaged us to do that interactive process with them. So last couple of slides, and then Denise, we're gonna just squeeze in a couple of questions real fast. So just a reminder on confidentiality. Don't talk about, what you're doing or disclose the fact that any of your employees has a disability. And if you say like, hey, we went through, interactive process and that's a reasonable accommodation, it pretty much you're telling your coworkers that person has a disability. The other thing to keep in mind is when employees are returning to work, don't say like, hey, we're going to require a full release from your doctor, because that phrase full release it implies that you're not going to engage in the interactive process if they have any sort of restrictions. So just, how you doing? Make sure you train your managers. How you doing? You could use the phrase, are you going to be able to perform the essential functions with or without a reasonable accommodation? You could ask a question like that, but just be careful about the language that you use. And I know we're 11:59, Denise, but do you have any burning questions out there that
I have a couple.
we can
I
answer?
have just a couple. Yeah, sorry.
And if people have to jump off, let me do it this way. Let me say this real fast, and then we can stay a couple extra minutes. But if people have to jump off, our next webinar is December 9th. So if you downloaded the PDF handout, you'll see the link right there to register. Note that it's going to be 90 minutes. We think at this point it's going to be 90 minutes, okay? So just plan on that. And if we can get done faster, we will. But that's going to be our next webinar, New Laws for the New Year. That's always a big one, so register soon. Okay, Denise, now we'll take questions.
Okay. One other comment: if you have questions, we don't get to them, we'll circle back with you after the webinar. So don't feel like you can't get a question answered. Okay. Are medical reasons the only type of reasonable accommodation, or are there other examples we should be aware of?
Well, we just talk about for COVID that the sincerely held religious beliefs would be another one. But when we talk about the interactive process, most of the time we're talking about it's a disability related situation. Okay.
On not sharing accommodations and how it affects other employees, can you share the necessary information with the management or the HR staff?
Yeah, anybody that has a need to know, right? Again, you want to be careful about what you're doing, but let's say, um, like HR is usually the one that's going to conduct the interactive process, right? Let's say that they engage in the interactive process. I would usually bring in that supervisor to help brainstorm and everything, because they're going to be there on a daily basis. And if the person has a medical condition, that needs monitoring, it's always good to let the supervisor know, right? In case something happens to the employee. But we just mean don't go out and just tell everybody like, hey, this is what's going on. And you might notice Susie Q takes her lunch earlier in the day and this is why. Don't be doing that, right? But if there's a need to know, um, with a supervisor, direct supervisor like that, that's fine. You have to be careful though, and Kurtis, maybe you can weigh in on this, is I've had this come up before where like the CEO of the company will say what's going on with that person and HR doesn't want to tell the CEO what's going on.
Yeah, and that's appropriate for HR to keep it confidential. If the CEO is not in a position where the CEO needs to know, then the CEO shouldn't know. It's only for HR and management employees who are in a position where they need to know so that they can provide the accommodation to the employee. Just because you're in a management position, you're not entitled to the gossip, right?
Right, and yet that's a tough one, right? Because CEO shows up and says, what's going on? You
Well,
have
we've
to
made
be,
an accommodation.
yeah,
That's about
exactly.
it.
Right.
That's a tough spot to be put in.
It is. Been there
Yeah.
before.
Yeah. If you have an employee who is saying they're in pain and can't do certain functions, but have not provided a doctor note, what doctor do you send them to for verification and give them the job description? So I think what they're really asking is what kind
I
of
got it.
doctor to send them to. And
Yeah.
okay.
I got it. So first step is I would send them to their own doctor, right? If they're telling me they can't do some essential job function, they were hired to do that job. If they can't do it, then they should go to the doctor and here's a certification form you can have the doctor fill out, right? That's usually the first step. If they don't have a doctor or for some reason we decide we didn't like what their doctor had to say or it was too vague, then if you want to send them to a doctor of your choosing, you can choose that doctor. I normally recommend go to an occupational health facility, right? So
Yeah.
whoever does your workers' comp is a great choice. If you do pre-placement physicals, send them there. It's probably the same one. But if it's an occupational health provider, that's going to be your best bet, right? Because they're used to the forms, they're used to doing that type of analysis, and they're going to be in a better position, in my opinion, to make that determination. Did you want to add in there, Kurtis?
No, I agree. That's exactly what I was going to say.
Okay.
All right. Then I'm going to just wrap up with this last question, and we'll get back to anybody whose questions we didn't get answered. We want to be mindful of your time. Is working from home a reasonable accommodation when our office policy is now back to work in the office full time?
It depends. I'm sorry to give you the lawyer's favorite answer, but
I was going to say, that was wussy.
it depends entirely on the facts and circumstances of the employee situation. Why is the work from home being requested? It's an individualized assessment, and there's probably not enough facts in there for us to make a conclusion or make a recommendation. But potentially, it could be an accommodation that somebody could still be asking for, and you'd have to go through the process to determine if it's reasonable or whether it's an undue hardship.
Right. So yeah, so I'll just add on that. I can hallucinate circumstances under which, yes, it's going to be a reasonable accommodation. Let me put it this way. It's definitely an accommodation. Whether it's reasonable, I think Kurtis's point is it's very fact specific, right? So we'd have to know more about it. But let's say I broke my leg. I don't want to wish it on myself. Let's say somebody else, Susie Q, we'll keep hurting Susie Q. Susie Q breaks her leg and she can't drive a car, right? It's like, are there other ways for her to get to the office? Yeah, you could hire her an Uber driver. You could, there's probably other ways to get her to the office. But one of the reasonable accommodations would be to have her work from home, right? So at the end of the day, you have to ask yourself, okay, so which is better? We're going to have the cost and expense of sending a driver for her every day. You could do that. but you could also say, okay, it's fine. You can work from home for the next 4 weeks, 6 weeks until you can drive, whatever it is, right? So there's certainly times where that's going to be the case. I did notice on here, Denise, somebody asked about whether it's going to be recording. If the GoToWebinar gods complied and everything else worked out, then yes. If you have not already done so, we would encourage you to go out to YouTube. Go to youtube.com/Ethos HCS. Or Kurtis, do you know what yours is? I should look that up.
I don't, but if you just search our law firm in YouTube for Merhab Robinson Clarkson, our page should pop right up.
Yeah, so we both have pages. You can subscribe to it, and then you'll be notified whenever we post a recording there. So if you go out to ours, which is this /Ethos HCS, which is the same part of my email address there, then you'll find where all of our prior webinars are, and you can access those there as well. And with that, Denise, I think we're going to thank everybody, and thank you, Kurtis, as always, for your expertise on this.
My pleasure.
And I will say thank you all for attending and hope to see you in December when we talk about new laws for the new year. Have a great day, everybody.
Yay.